All right, well, we are off to Bellingham. Start of a new week. First full week in phase 2 after this crazy COVID stuff, right? Still going on, we're in phase 2, but now businesses are gonna be mostly open with a lot of restrictions. But I will begin my normal usage of all my remote offices for the most part. I mean, I'll probably not spend as much time per day there, but get that routine going again. Start getting me used to it, right? I mean, I've been out of practice with all my commuting, so I guess that was one good thing about this quarantine. Not that there was really much good about it, but one thing was that I didn't have to drive around as much, and I was able to stick around home and around my main office. So today we will start our discussion of bankruptcy law, the basics basically. We'll go right to the beginning. And I'm gonna talk about this just a little while we're driving here. And I mean, first things first, what's the whole reason we have bankruptcy, right? I mean, what's the purpose? What's the purpose of bankruptcy law? And there's really two main purposes. So the first one, which is the one that I'm most concerned about, is that debtors, people that are in trouble financially, are able to get a fresh start. So that's first and foremost in my mind. The main purpose of bankruptcy law is to find ways to get debtors out from under all of that crushing debt and off to the races in a new, fresh start on their financial lives. Right. And the reason we do that is, as a country, as a policy matter, is that we don't want people languishing around out there under, crushing debt that they maybe have no hope of paying off, or if they were possibly able to pay it off, it would just suck out all the financial resources out from them and their family for years and years to come. And obviously, if that were to be the case, then most people's will to keep going and working, starting a business or running a business, those things would go away, right? You would have no real desire or drive left in you to keep going under those circumstances, with creditors calling you and trying to collect from you and suing you. All those things really just crush the life out of a debtor. Now, I mean, those things like collections and those types of actions that creditors take, they serve a purpose too. Not that that's something that I do. I choose to not engage in that type of legal activity, but it has a purpose. But when there's too much of that, or somebody just has no real shot at getting out from under the debt, that type of collection activity just really starts to just suck the will and drive, desire to keep moving, putting one foot in front of the other, out from the debtor and who knows where that ends, right? I mean, people start to pull into their shell, and maybe they don't want to work even. Possibly start going on federal benefit programs just to basically have some food on the table, and that's just no good for society. I mean, we have those programs there for people, safety net programs to help when it's absolutely necessary, but we'd prefer if people have their health and they're they're still young enough and they're not deep into retirement. We'd like them to be able to work, right? So that's the whole purpose of a Fresh Start, is to get people back into financial shape to be able to move forward, take some risks, maybe, no risk, no reward, right? And our country's built on a capitalist system that requires people to start businesses and take risks, calculated risks, no doubt, right? I mean, you don't want to take too many risks, but I mean, that's up to each individual and the business model that they're operating under. But the more risk, the more reward, or the more pain, right? I mean, if you take a lot of risk, sometimes it doesn't pan out and people fail. So we have a safety net for that, and that's what bankruptcy is. Because when people do take risks, they fail. That doesn't mean that they get out of jail free, right? I mean, they feel some pain, but we don't want them in that pain for too long, and we don't want them to be left with nothing. And so, especially when we're talking about individuals, people, right? We want them to have a fresh start, and we want them to have something that they can use for that fresh start. So that's a minimal amount of assets, I mean, maybe you have a house and you have a bunch of equity in that house. You might be able to protect that equity, right? And that equity could be maybe the fresh start, the little nest egg that you need to help you start the next chapter of your life. So that's what the main purpose of bankruptcy is for the debtor. Okay, and then there's another whole side, other purpose of bankruptcy, and that's for creditors, right? I mean, that's to make sure that creditors are treated equitably, fairly, right? So all creditors are treated the same. No creditor is treated better than another creditor, depending on their situation, right? I mean, a secured creditor will have better treatment than an unsecured creditor, because they have an asset, they have collateral. But similarly situated creditors will be treated the same, okay? And that's the purpose for creditors, is that they don't have to be the most aggressive creditor to make sure that they get their piece of the pie, right? And that's why, before someone files bankruptcy, there's a lot of calls and there's really aggressive creditors, and then there's some creditors that don't really do much, right? I mean, there's, maybe they're even asleep, maybe they don't even know, and so they're not going to get anything, right? But then the most aggressive creditors, the ones that are, burning up the phone lines and maybe even, making almost like threats to the debtors, which they shouldn't be doing, but some of that stuff happens, or people take it that way, and so then they get paid, right? And so they're the most aggressive, so people will sometimes pay them before they pay other creditors that aren't calling them, and so those creditors that are the most aggressive get treated better, right? But that's before bankruptcy is filed. So once bankruptcy is filed, the calls stop by law, right? All that stuff stops, and the creditors are okay with that generally, because they know that they're going to be treated fairly. They're not going to get anywhere if they try to collect, more aggressively, because the law and the courts will demand that they only get what they have coming to them from what's available, And so that's the other main purpose, is that we treat all of the creditors fairly in bankruptcy, and that causes a process to get underway that is much easier to deal with, right? I mean, no creditor is going to be, working, super fast to get everything done, because they can't, I mean, they don't have any way of getting any more collection than the other creditor by moving quicker or those kinds of things. I mean, they have a few tools that they could possibly use, but they have to all go through the court. I mean, they have to file a motion with the court to try to do anything. And in order to do those things, to file a motion to like lift the stay, so that they can continue to collect, from the creditor, from the debtor, they have to have a good reason to do that. I mean, they can't just do it, right? I mean, they have to have a good reason why they should be treated better than all the other creditors, and they need to be able to explain that to the judge and defeat the debtor's attorney, who's going to be arguing that that creditor is not entitled to any special treatment. So they don't do that unless they think they have really good cause for it. So there's just a fair process according to the law. Everybody knows what they're going to get. The creditors know. In the case of a Chapter 7, which is one of the easier types of cases when we're talking about consumers, the creditors know that in most cases they're not going to get anything. There's zero, right? I mean, unsecured creditors are going to get zipped. And if there's nothing there, then they just know to just quit calling, put that collectible on the back burner, because they're not going to probably get anything, and they don't do anything, and then they just wait and see, does this case, bankruptcy case, go forward, and does it complete? Is there a discharge? And when there's discharge, then they know that they just not going to get anything, and then they write that debt off if they haven't already, and they move on, right? That was the risk for them. A creditor takes risks to extend credit to a consumer, knowing full well that in some cases things don't go well for a consumer, and they might not be able to make all the payments, and the creditor might lose some money, right? And so each time they extend credit, they have to weigh all those risks, and that's why they run credit checks on people. They're determining, what's the likelihood that I'm going to collect all of this money back. And if the likelihood is really good, somebody has really good credit and they have good income, all that kind of stuff, then they're going to charge a lower interest rate, maybe, or they're going to, extend that credit real fast, no problem. But if they feel like there's more risk, then they're going to, think about it a little harder. They may, want a higher interest rate to help compensate for that extra risk that they're taking on. And, in some cases they just won't extend the credit, right? I mean, if somebody's credit's really bad, or they're really underwater, and there's not enough income to justify making the loan, then they just won't make the loan. So, but that's the risk reward system, capitalist system that we live in. And so other main purpose for bankruptcy is to make sure creditors are treated fairly, and they have a way to recoup what they can. But if there's nothing there, then they can just move on too, right? I mean, the court and the trustees are going to look everything over, make sure that the debtor doesn't have anything, right? And if there's nothing there, then they can just give up, and they can move on and write the debt off, and get on with their business of moving on, loaning the money out, new money out to other people, and not have to spend the time making phone calls and trying to collect money that they're never going to get anyway, right? So those are the two main purposes. So moving on from that, let's talk a little bit about the jurisdiction of the court, right? So bankruptcy court, the courts are federal courts, so they have pretty wide jurisdiction, right? I mean, they have jurisdiction around the entire country. They can, any creditor, no matter where they are in the country, can be involved in a bankruptcy case. Okay, and there's some other little wrinkles for a debtor that where can they file the case, right? I mean, you're going to usually file the case in your local bankruptcy court. That's like a venue question. Also, like, which court do I file it? But, generally the bankruptcy court as a system, has jurisdiction over all United States citizens and people that live here, residents that are in the country, and people that own property here and in the United States. They are all able to file cases and be involved in cases in bankruptcy. course, most bankruptcy cases have to do with money, right, and debt. And so that's the bulk of the cases that they'll hear, but I mean, there's a lot of things from outside of that world that can actually get pulled into a bankruptcy case. It doesn't happen that often, but the bankruptcy court has jurisdiction to hear cases that arise from the bankruptcy code, right? So the controversy is in the bankruptcy code, Title 11, and all of the laws that are listed there. But they also have jurisdiction to hear cases that arise indirectly from the bankruptcy code. So it might not necessarily be a debtor-creditor situation, but it might be a contract issue. But that contract issue is arising out of some other body of law, but it ties into Title 11, and it may possibly cause a debtor to become insolvent, that kind of thing. So the bankruptcy court can hear those types of cases as well. Sometimes a bankruptcy court or judge can issue orders. In most cases, the cases they deal with, they issue orders that are final. Those are final orders. And of course, they can be, you can appeal that through the bankruptcy system, and then up and through the federal courts. But then sometimes, depending on the matter at hand, if it is not something that is a core bankruptcy proceeding, that judge can still decide that matter, but that order will not be final. What they'll submit is their findings of fact and recommendations for conclusions of law, right? And they submit that to the federal court, district court, and then that's where the final order would come from. And that's not run. You don't see that very often in bankruptcy. There's some interesting cases there, though. There's some really interesting cases. I'm thinking about having a segment of my video commentary deal with some of those interesting cases, and then go into that. Some of those cases involve some fairly famous people that have had a big impact on bankruptcy law, and some of that those cases have come into bankruptcy through other avenues, like probate, right? And so when somebody passes away and there's money, involved, sometimes probate cases can end up in a bankruptcy proceeding. And so just thinking of one case in particular that I think is interesting, and we'll go over that some other time. But those are some of the jurisdictional issues that we look at. It doesn't really impact too often, but most of the time, anybody that's in the United States can file a bankruptcy case in the courts. And then on the venue side is which court do you use, and that gets into residency questions. So if here I am in Washington, and I'm in the Western District of Washington. If you've lived in this district for anything more than 3 months, then you can file a case in this court here in the Western District. And the rule there is, where have you lived in the last 6 months the most, right? And so if in the last 6 months you live here the most, which would be 3 months or more, right? Generally, then you can file here. Okay. I guess you could have a situation which doesn't come up often, but maybe somebody lives somewhere for 2.5 months, and then they lived at another place for 2 months, and then they lived at another place for a month and a half, right? The place they lived for 2.5 months would be the most, and so they would be able to file the case here. Now, just because you can file the case here doesn't mean that that's the law that's going to apply. I mean, most of the time, bankruptcy law is federal law, right? That's going to apply for most things, but there's several areas in bankruptcy law that lean on state law, okay, to determine the outcome of certain issues. And if you've lived somewhere less than 2 years, then the state law from that state may not be what's going to be used to figure out what the answer is to that question. And so you've got to go look at which state have you lived in for the last 2 solid years, right? And if you haven't lived here in Washington for the last 2 solid years, then you may not be able to claim, for instance, Washington exemptions. Okay, and that might not be a big deal, but we got to know that answer, right? I mean, we got to figure out which body of law can we use to exempt property, and if we can't use Washington, then what do we use? Right? I mean, do we use federal law, or do we use maybe the law from the state that you moved from? So sometimes that happens. We might need to go to the state of Texas, and see what Texas says about certain matters. So it doesn't come up that much, but it does. I mean, people move around the country, and especially if people are looking for work or they ran out of money somewhere, sometimes they do move, and so that comes up. We've got to look at which state will we use for certain types of laws. And exemptions being probably the biggest one of those, but there's other areas that impact. So there's a few little extra things there for you to think about. I was going to talk a little bit, and maybe we have time here, about who can be a debtor, right? Who can file a bankruptcy case, right? And the answer is different depending on which chapter you're looking at. So just briefly, in Chapter 7, almost anybody can file a Chapter 7. When I say almost anybody, I mean even entities, right? I mean businesses can file Chapter 7. Corporations can file Chapter 7. They don't do it very often because Chapter 7 is liquidation, right? It means you're not going to be in business anymore. And there are reasons to do it sometimes, but the main point here is that not everybody can file a Chapter 7, but most people or most entities can, and most individuals can for sure, right? I mean, unless you don't live here, you're not a resident, you're not a citizen, you own no property here, you probably can't file a case here in the United States bankruptcy system if you have no contacts, right, with the United States. But, most of the time people that are situated like that probably aren't going to need to file a bankruptcy case. But you can't, right? I mean, you have to have under the code, the right to file a case. So that's down in Section 109 of the Bankruptcy Code, which is entitled to be a debtor, right? So other little wrinkles, in Chapter 7, who can't be a debtor in Chapter 7? Well, it's a very small group. It's from a business perspective, railroads, they can't file a Chapter 7. I don't know the reason why. I mean, that's probably something that was put in there way, way, way back, but they can't file Chapter 7. And then banks can't file a Chapter 7 either. So that's probably good. Banks can't just come in and say, okay, we're done, we're going to liquidate everything. They can't do that either. So they have ways that banks go under that they can use different sections for the most part. And there's ways that banks can deal with situations where they need relief, but they can't do it under Chapter 7. Okay, so those are just some of the few exceptions there. What about Chapter 13? Well, Chapter 13, which is another area for consumer debtors. Chapter 13, the big restriction there is that you have to be an individual, right? I mean, you can't be a corporation, you can't be a company. You have to be an individual, a person, to file a Chapter 13. And Chapter 13 is like a reorganization type of chapter, and it's meant for people. Chapter 11 is a reorganization chapter that is mainly meant for businesses, although Chapter 11, individuals can file under Chapter 11 as well. And sometimes we use Chapter 11 for people, for individuals that can't use Chapter 13. And the big reason that an individual would not be able to use Chapter 13 is if they have too much debt. Okay? So Chapter 13 is there for people that have a lot of debt. Usually it is people that have a lot of debt, but they also have pretty decent income. They just can't pay all their debt. They've taken on too much. They don't have enough money to pay all their debts, but they can pay some, right? And so that's usually the people that end up in Chapter 13. And if they have too much debt, and there's some very specific numbers that are in the bankruptcy code, and they get adjusted, from time to time, to tell us how much we need to look for as far as debt. And there's two numbers that you have to look at. One is the unsecured debt, and that number is generally around $400,000. So if you have more than $400,000 of unsecured debt, then you're not going to be able to file in Chapter 13. And then we look at secured debts. And secured debts, you can have the numbers like around 1.2 million of secured debt. Okay, and that's per person. So if you're filing a joint case, married couple, then you just double those up, right? But unsecured or secured debt of 1.2 million, and so that we think, oh, that's a huge amount, and it is a big amount. But here in Washington, the secured debt includes like your house, right? And so if you have a big old mortgage on your house, then you might, and as an individual, down in Seattle, some people might have, a secured loan on a house. They might have a second home. They have a secured loan on that. One house maybe $700,000. The other house is, $500,000. Then they've got some cars. Secured car loans, those kinds of things. And if it's an individual, one person, it's very easily for them to get over 1.2 million. Now all of a sudden, they can't file Chapter 13. So for individuals like that, Chapter 11 is the outlet. And Chapter 11 is definitely, it's good there is a way, right? I mean, you don't want to be stuck with no avenue for relief. So people in that situation do have an avenue for relief, but it's Chapter 11, which is mostly for businesses. And it's very expensive. It's expensive. There's a lot of court time involved in a Chapter 11. There's a lot more creditor involvement. There's fewer attorneys will take your case, right? Because these are very complicated cases that take a lot of time and effort, and so you're going to have to look a little harder to find an attorney that's going to help you. So those are some of the ins and outs of who can be a debtor, and hopefully those 3 topics we covered today were helpful for you. I'm actually here in Bellingham now, so I'm starting to approach my remote office, getting closer, and I'll have to probably cut off here and let my audience go, but there will be more. We're gonna do a lot of coverage of the bankruptcy code over the next several weeks, and see if some of this will help you. If you find yourself in a situation that you're needing help financially because of this coronavirus, and being out of work as a result of that, or something of that magnitude, right? And something big has happened and it's causing you financial difficulty. You're not sure if you're going to ever get out of it, and you need to talk to a bankruptcy attorney to see what the bankruptcy code can do for you, then give us a call, or talk to a bankruptcy attorney in your area, wherever you may live. And I hope that things go well for you. I hope you're able to dig out of the financial mess that you're in that maybe wasn't even your doing, right? I mean, this coronavirus has done that to some people. I think that we didn't know this was going to hit us, right? So do your best, but sometimes, as we talked about, the purpose for consumers, bankruptcy is one of those tools that we have out there for you to help you get a fresh start, get out from under all of this crushing debt, and get back on the road to success and financial security. All right, I'm Mark News, Westward Law. Take care.